Hello and welcome to LiveLaw Daily. Today is 7th August, observed across India as National Handloom Day, a day that celebrates the country's rich weaving tradition and the millions of artisans who keep it alive. The handloom sector supports over 35 lakh weavers and allied workers, with women making up nearly 3/4 of the workforce. It's a reminder of the skill, craftsmanship and livelihoods that continue to shape one of India's oldest industries. I'm Debojit Das, and here are today's top legal stories. Our first story deals with a case that raised an uncomfortable question for the Bombay High Court. What happens when an elected representative is accused of assaulting the very people he is meant to serve? The case concerns Shiv Sena's Shinde faction corporator Ramesh Mhatre, who along with 3 associates is accused of assaulting 3 doctors at a civic hospital. Today, the Bombay High Court granted bail to all 4 accused, but only after imposing some unusually strict conditions. A bench led by Acting Chief Justice Ravindra Ghughe made it clear that this wasn't an ordinary bail order. The court directed Mhatre and his associates to stay out of Maharashtra until the prosecution files its charge sheet and the trial court frames charges. Wherever they choose to stay, they must report to the local police 3 times a week, surrender their passports, and are barred from contacting witnesses or tampering with evidence. While dictating the order, the acting Chief Justice made a strong observation on the role of elected representatives. The court said, "The rule of democracy is elected representatives are by the people and for the people. But if any elected representative assaults voters, such a situation will dent the very fabric of democracy." The court also directed that the trial be fast-tracked, asked the state to appoint a special public prosecutor who should continue throughout the case, and ordered police protection for the 3 doctors. It further directed the Kalyani Dombivli Municipal Corporation not to initiate any disciplinary action against the doctors over the incident. Once the charge sheet is filed, the accused will be free to re-enter Maharashtra. Our second story deals with a case that prompted the Supreme Court to ask a difficult question. When a critically injured child reaches a hospital, can the lack of facilities ever justify refusing immediate treatment? The case concerns the rape and murder of a 4-year-old girl from Ghaziabad. While hearing the matter, a bench of Chief Justice of India Suryakant, Justice Joy Mallya Bagchi, and Justice V. Mohana examined the conduct of 2 private hospitals that treated the child before her death. Senior Advocate N. Hariharan, appearing for the girl's parents, told the court that the special investigation team's report painted a damning picture. According to him, the first hospital failed to call available doctors to provide emergency treatment before referring the child elsewhere, while the second hospital, despite having multiple departments, also failed to save her. He argued that the child might have survived had timely treatment been given. As the court considered compensation, both the hospitals agreed to make payments voluntarily. St. Joseph Mariam Hospital agreed to pay 10 lakh rupees, while the second hospital agreed to pay 2 lakh rupees, both within 4 weeks. They, however, requested that these amounts be treated as voluntary contributions rather than compensation, since the criminal proceedings are still pending. The hearing also raised concerns about the police investigation. Hariharan pointed out that the FIR was registered nearly 30 hours later and initially mentioned only murder without including rape. Justice Joy Mallya Bagchi made an observation during the hearing too, saying, "This was a 4-year-old girl who had suffered such a traumatic attack. The bare minimum which could have been administered was some blood, and yet you packed her off." The Supreme Court has now indicated that it will frame broader guidelines to ensure hospitals provide timely emergency care in such situations, and has asked for concrete suggestions on how those safeguards can be strengthened. Our third story deals with a business dispute that has now brought Bollywood actor Salman Khan's company Being Human before a Chandigarh court. A local businessman has alleged that he invested nearly 3 crore rupees to open a Being Human jewellery showroom after being assured the business would be profitable. According to the complaint, more than 1 crore rupees was spent on setting up the showroom and all contractual obligations were fulfilled. But after the showroom opened, the complainant claims the promised business support never materialized. He alleges that jewellery supplies became irregular, the supplying outlet shut down in February of 2020, and the business suffered losses running into several crores. He also says he had been led to believe Salman Khan would personally inaugurate the showroom, but actor Ayush Sharma attended instead. The complaint accuses 6 individuals, including Being Human, Alvira Khan Agnihotri, and the directors of Style Quotient Jewellery, of misrepresenting the business opportunity to induce the investment. Judicial Magistrate Dr. Ambika Sharma has therefore now issued precognizance notices to all the accused under Section 223 of the BNSS. The matter will next be heard on October 5th. Our next story deals with the Supreme Court's ongoing hearing into the alleged audio clips set to implicate former Manipur Chief Minister N. Biren Singh in the state's ethnic violence. The court has now directed that the latest forensic report prepared by the National Forensic Sciences University, or NFSU, be shared with the Kuki Organization for Human Rights, which is seeking an independent investigation. At the same time, the bench made it clear that the report must remain confidential and not enter the public domain. A bench of Justice Sanjay Kumar and Justice Sanjeev Sachdeva was informed by the centre that the National Forensic Sciences University found the audio clips had been altered, including the first-generation copy provided by the whistleblower. And because of those alterations, the agency said it could neither authenticate the recording nor compare the voice with Biren Singh's admitted voice samples. The centre argued that the clips were clearly manipulated and urged the court to dismiss the petition. Appearing for the petitioner, Advocate Prashant Bhushan disputed that conclusion, pointing out that an earlier analysis by Truth Labs had found with over 93% certainty that the voice in the recording belonged to Biren Singh. Bhushan also informed the court that he intended to share the NFSU report with Truth Labs for its opinion. The matter forms part of a long-running effort by the Supreme Court to authenticate the recordings after multiple forensic examinations failed to reach a conclusive result because of concerns that the audio had been modified. Our next story deals with a Supreme Court hearing where a request to appear virtually before the police ended with some pointed remarks from the bench. The case concerns Trinamool Congress Member of Parliament Mahua Moitra, who had challenged a Calcutta High Court order directing her to appear before the investigating officer on August 14th in a case alleging that she offended religious sentiments. While the High Court had protected her from arrest, it required her to cooperate with the investigation. Before a bench of Justice Dipankar Datta and Justice Sheel Nagu, Senior Advocate Gopal Shankar Narayanan clarified that Moitra wasn't seeking to avoid the investigation. Instead, she wanted permission to join the questioning virtually, citing security concerns after eggs had allegedly been thrown at her during earlier public appearances. Justice Datta, however, was not persuaded. Questioning the request, he remarked, "Having taken the plunge into politics, why do you fear eggs being thrown at you? Our freedom fighters took bullets on their chest." He also asked whether the virtual appearance was being sought merely because Moitra is a member of parliament. Following the court's observations, Shankar Narayanan withdrew the petition and the Supreme Court permitted its withdrawal. Our next story deals with a Delhi High Court order that has temporarily halted action by the food regulator against Dabur India over its 100% product claims. The dispute began after the Food Safety and Standards Authority of India directed Dabur to stop selling products such as honey, cow ghee, edible oils, coconut water, and apple cider vinegar carrying 100% claims, saying those claims were ambiguous, unverifiable, and likely to mislead consumers. Dabur challenged the order before the Delhi High Court, arguing that it had been passed without a show cause notice or even an opportunity to be heard. The company also questioned whether the FSSAI had the legal power to issue such a prohibitory order. Hearing the matter, Justice Amit Mahajan observed that at least prima facie, such an order should not have been passed without following the principles of natural justice. The court noted that Dabur had been selling these products for many years and stayed the authority's order until the next hearing. The High Court has now issued notice to both the central government and the FSSAI, with the matter scheduled to be heard next on August 24th. Our next story deals with a question that could affect thousands of medical students across the country. Should there be one national policy on compulsory rural service? The issue came up before a bench of Justice P.S. Narasimha and Justice Alok Aradhe, which was hearing a challenge of Karnataka's rule requiring medical graduates to complete 1 year of compulsory rural service before they can obtain permanent registration with the Karnataka Medical Council. During the hearing, Justice Narasimha indicated that this is an issue that goes beyond Karnataka. He observed that medical education is heavily supported by the state, directly or indirectly, and that doctors also have a role to play in nation building. He suggested that there should be a uniform policy across India on compulsory rural service instead of different rules in different states. The Solicitor General agreed to seek instructions from the centre on whether such a nationwide policy would be formulated. The petition has been filed by students who studied on private seats in private and deemed universities. They argue that since they pay substantially higher fees, they should not be treated the same as students studying on government-funded seats for the purpose of compulsory rural service. The Supreme Court has now adjourned the matter for 3 weeks, giving the centre time to respond on the possibility of a uniform national policy. Our next story deals with a Delhi High Court hearing on whether a small, peaceful protest should even require judicial intervention. The case was filed by the All India Dalit Christian Rights Protection Committee, which wants to hold a 3-hour protest at Jantar Mantar on August 10th, seeking scheduled caste status for Dalit Christians. The organization says it applied for permission nearly a month ago, but despite repeated follow-ups, the Delhi police never gave a written decision and only orally informed them that permission would not be granted. Before Justice Amit Mahajan, senior advocate Sanjay Ghosh clarified that the petitioners were simply asking the court to direct the police to take a formal decision on their application. The Delhi police opposed the plea, pointing to security arrangements ahead of Independence Day, the operation of Section 163 of the BNSS, and the fact that the Supreme Court is already considering the future of Jantar Mantar as a designated protest site. The Additional Solicitor General also cautioned that a gathering of 75 people could quickly grow much larger. In the end, the High Court did not decide whether the protest should be allowed. Instead, it directed the Delhi police to take a decision on the application and communicate it to the organizers by the next day. Our ninth story deals with the Karnataka High Court's intervention in the alleged KPSC recruitment scam, even as demands grow for a CBI probe. The High Court was hearing a batch of petitions, including one by BJP MLA BP Yatnal, seeking a CBI investigation into multiple recruitment processes conducted by the Karnataka Public Service Commission. Another petition alleges large-scale corruption in the recruitment of 400 veterinary officers, while a successful candidate has sought quashing of the FIR against him. Before Justice M. Nagprasanna, the petitioners expressed concern that the CID might rush to file its final report before the court decides whether the probe should be transferred to the CBI. Taking note of that concern, the court directed that no final report should be filed in any of the connected cases without its prior permission, even if the investigation is complete. The allegations before the court are serious. One petitioner claims middlemen demanded 80 lakh rupees per post, with candidates allegedly being taken outside Karnataka for training using question papers and answer keys. It is also alleged that confidential candidate data, including addresses and phone numbers, was accessed by middlemen, and that one candidate related to the suspended KPSC chairman secured unusually high marks despite an average academic record. The court has also recorded the state's assurance that no coercive action will be taken against successful candidates who cooperate with this investigation. The matter will now be heard next on August 20th. Our 10th and final story deals with a Karnataka High Court hearing that left the judge questioning how a sitting MLA could not be served with a court notice. The case relates to a criminal defamation complaint filed by an RSS worker against Congress MLA Dinesh Gundu Rao over alleged remarks about the RSS. When the matter came up before Justice M. Nagprasanna, the petitioner's lawyer said that even after 3 weeks, the police had been unable to serve notice on the MLA. The court's reaction to this was, "It's shocking to hear that MLAs and ministers cannot be served. Ministers and politicians in the opposite building are not being able to be served." The state responded that service might already have been affected and sought time to verify the position. The case arises from a challenge to a magistrate's order that had dropped proceedings against Dinesh Gundu Rao while taking cognizance against Karnataka Home Minister Priyank Kharge and Congress leader Mohammad Haris Nalapad over alleged defamatory remarks against the RSS. The complainant alleges that Dinesh Gundu Rao actively endorsed social media posts linking the RSS to the murders of Gauri Lankesh, Govind Pansare and MM Kalburgi and was not merely forwarding someone else's content. The High Court has now posted the matter for further hearing on August 13th. That's all for today's edition of LiveLaw Daily. For detailed reports on these stories and more, check the description box below or visit livelawin. Thanks for listening, take care and we'll see you next time.